Kim Rubenstein is an expert in how our Constitution works, and we wanted to talk to Kim tonight because, well, these border bans, which have been standing in place for some time, well, they may well, of course, be illegal. Kim, nice to talk to you.
Great to talk to you too, Paul.
So we know that there has been, of course, attempts by Clive Palmer in the past and others to try to get to the particular section of the Constitution to make sure that these state borders can come down. But is it your belief that the nature of the health pandemic changes the ability with which a state could defend its capacity to have a border up right now?
So, yes, the situation, Paul, is that Section 92 of our Constitution, which was part of the arrangement of the colonies in their whole deliberation of creating a federal Commonwealth nation, was to ensure that there was a uniform economic framework. And so Section 92 says that no state can really restrict trade in a way that protects or advantages one state over the other. But the High Court, in its interpretation of Section 92, has recognised that if the state is trying to regulate for some other purpose rather than economic protection, well, then they can do that as long as it's proportionate to that end. And that's the framework within which, of course, the state borders were shut. And the question was at the time when Clive Palmer challenged it, was that proportionate to the end that they were seeking about health protection? And the High Court recognised at that time that the health conditions were such that it was, in fact, valid. But this was all pre the vaccination scenario. And of course, as we know, the health framework and our understandings and the evidence around it has changed. Well, not so much the evidence, but the conditions have changed. So what I have said is that raises a question as to whether the scenario now is such that a challenge would be stronger by virtue of the fact that the health needs have changed, and are these closed borders still proportionate to those health needs?
Now, of course, to anticipate what a court would do is, a fool's game, so I won't even start. But yes. Obviously, all of this depends on your perspective about where you're watching this TV show tonight. So if you're in New South Wales and you're in Victoria, the concept of wanting to go to Queensland is one where, well, this border has to come down so I can go to Queensland. But if you live in Queensland with 0 cases and they hit 70% first jab today, they might be able to get to the 70 and 80% double jab without the simultaneous issue of number of cases that exist. So when the court considers something like this, do they literally go, well, hang on, how many states have one position versus how many states have another? Or is it about, walk us through what you think the process is.
Look, there are a couple of interesting issues that you raised there in just that scenario. And one, of course, is that as a nation, there are people who have family members all over the country. So there is also that notion that as one nation, we have to be thinking about what is in the interest of the greater national good and what is specific and territorial. And as you were saying, each of the different territories may have particular conditions that make it different. But ultimately what the High Court has to do is really assess whether the legislative intention of the state that is creating the closed borders is truly linked to that health need of their state, because they're regulating for their state. Each of the different jurisdictions around the country, our parliaments there have a responsibility to the people that elected them. That's our democratic framework. But the people that elected them are in a context where there are restraints on what their leaders can do in their interests. And so it's really that balancing act in each different state that the High Court would only interpret for that particular state's evidentiary needs about protecting the health scenario and whether what they are requiring is proportionate to their health needs. So yes, it is specific to each of the different states, but I think your introductory point is interesting on a broader sort of leadership question about the national vision for the nation as a whole and how we manage a nation where there are people with families and connections, not to mention, and this is where the Section 92 issue comes in, the trade within the nation. And so airlines, for instance, and travel companies who have a whole national business interest are no doubt assessing whether the time is nigh for them to consider an application to the court as to whether these restrictions on their trade, their their trade between the states is proportionate to the health end of that particular state. And that's what we may see come before the courts.
Kim Rubenstein, it's awesome to talk to you. And I would love to be a fly on a wall at a barbecue where everyone's arguing the finer points, not of the Constitution, but when you've got a big brain like yours, I hope that you argue about song lyrics with the same specificity and detail.
I can. Do you want me to start on that next call? I'm more than happy to.
We will.
I do encourage people. I think it's really important for Australians to be active citizens and to think seriously, and of course, with elections coming up, to think about what true representation means in a national sense and what good judgment and good policy represents for the future of our nation.
Bloody oath. Nice to talk to you. Thanks, Kim.
Thanks. Good on you, Paul.
I love big brain people. I'm obviously envious because